Well, good afternoon, and thank you for joining us. As you can see over my left shoulder, these live streams always come with some sort of unexpected event, and the box of diapers above my left shoulder was not intended to be there, but I'm not going to change it at this point. Uh, see a couple of you on here. I'm going to take a few minutes before we begin to enter some information, some ways for you to contact us, and I would invite you, if you have any questions throughout this live stream, please feel free to enter those questions in the chat box. And if I can't answer them, or if a member of my team can, we'll be glad to do so. Okay, great. Thank you for being here. My name is Michael Gault. I'm an eminent domain attorney with Bell, Carrington, Price, and Gregg, and we have a team of lawyers and staff that focus on representing landowners across a 5-state footprint in the Southeast. That's the Carolinas, Georgia, Alabama, and Tennessee. I'm the practice group manager for that team, and in that role, I help our attorneys and I help our clients to navigate eminent domain cases and condemnation cases all the time. That's all that we do. If you're here with us this evening, or if you're watching this recording at a later date, you know that we're here to talk specifically about a stretch of NC 150 up near Lake Norman. This is the Widening and Improvements Project that is really 3 projects broken down, or 3 individual projects combined into one large project. But that's important. The 3 individual projects that I mentioned, 2307 A and B, and then 1517, are important because of the funding timelines and implications, and then the right-of-way timelines and implications that are associated with each of those individual project numbers. For instance, 2037B and 5717 are currently funded for just over $250 million, and the funding for 2307A is yet to be determined. That's important because once the projects are funded, once they're placed in this particular timetable, in this particular section of the process, we know that right-of-way acquisition will be following. The information that we have and the information that you can find publicly shows that right-of-way acquisition is set to start in the fall of 2026. We are in the design phase, the final approval phases at this point. The first phase that should really concern you as the landowner would be the acquisition phase. That's when those of you that are impacted by this project will receive initial contact from a DOT employee or a third-party right-of-way acquisition agent, letting you know that the process is beginning, that your property will need to be acquired, or some portion of it, and that will really get us into this first phase. Let me back up a second and talk to you just for a minute about why it's important for you to be aware of this project and what your rights are as a landowner. Well, we know, and it's usually pretty commonly known by lay people, even non-lawyers, that governmental entities like the NCDOT often have the right to eminent domain. That just simply means that they have the right to take private property for a public purpose. Now, oftentimes when road projects like this come, property on both sides of an existing road that is widened or improved will need to be taken, or at least bought. That's the way that they like to couch it originally, is that we want to negotiate with you and purchase some property for new right-of-way or new easement. What often goes unsaid is that if those acquisition negotiations fail, if the settlement talks fail and they're not able to make an agreement and to buy property, then the right to eminent domain comes in through an action known as condemnation. That's a scary word. Oftentimes, landowners believe that condemning property means that they have to get out, that the property is, dilapidated or falling apart. That's not the context that we're talking about when we talk about condemnation in eminent domain cases. We just simply mean that even if the governmental entity, in this case the DOT, can't come to an agreement with the landowner, they have the right to file a document and to deposit some money with the court that they say the property is worth. And that gives them the right to essentially take rights to the area that they need to acquire to start working on the project. So, oftentimes landowners say, well, I'm going to play hardball. I'm going to hold them up. I'm going to make it take as long as possible. And in reality, that's just not the case. In reality, if they see that negotiations fail, oftentimes these files or individual tracts or parcels are submitted for condemnation. And that starts a legal proceeding where certainly in any legal proceeding, any lawyer would advise you to have legal assistance. Fortunately for our clients at Bell Carrington, our assistance starts well before the condemnation process in many cases. We like to be involved very early on. We like to be involved even during the design phase. There are all types of potential impacts, from what we would call residential strip takes, which are small portions along the frontage of a house that sits next to the roadway, all the way to complicated commercial and industrial impacts. And all of those have different concerns. Some of those can be alleviated by reaching out to the engineering folks or the project managers before the acquisition phase begins. If we see some issue where some right-of-way might be able to be reduced, or where a new road, new drive entrance may be allowed to enter onto a piece of property, those are all requests that we can at least make during this phase, during the early phase. The longer you wait and the longer the projects go into the acquisition phase, oftentimes the harder it is for the DOT to say, okay, we'll give you that, or we may be able to help you with that request. So it's helpful to get advice early and often. Oftentimes, and this leads me to one of my bigger points that I like to present during these town halls, is that landowners are often concerned about reaching out for legal advice early on in the process, or even at all. They think, well, what's a consultation going to cost me? What is the out-of-pocket retainer? What are they going to bill me hourly? If I call them now and the project's not starting until 26, what kind of bill I'm going to rack up before we even get to that point? And fortunately, at Bell Carrington, our eminent domain team has developed a fee structure that helps to calm those concerns. We operate on a contingency fee basis. That means that our fee is based on a percentage of the amount that we're able to get in just compensation for our clients, and it's calculated on what we call the new money, which is the amount that we're able to recover over and above the initial offer that the landowner receives from the condemnor, in this case, the NCDOT. We don't charge hourly rates. Our consultations are always free. We don't charge retainer fees. So essentially, there is no money due from clients out of pocket until the case is resolved, either through a settlement or ultimately your final right as a landowner in a condemnation case, which is a jury trial. Most cases never get that far. Most are able to be resolved through some sort of negotiation, either pre-condemnation or after a condemnation is filed. The only difference there is that when it's pre-condemnation, we're working oftentimes with a right-of-way agent, a non-lawyer. And then when condemnation is filed, we're working with an assistant attorney general who is assigned to the condemnation case. And so it's two lawyers working through the legal system to try to resolve that case. I'd like to leave you with this, and these are always brief. Most folks don't have the attention at 6 o'clock for a 30-minute call, but I can give you general information about the project. We can talk about eminent domain rights and remedies for landowners and for the state, but I can't talk about specific impacts without you reaching out to us. And so our names are in the chat box. My email and phone number are there. I'd invite you to reach out to me individually. If I can help you, I will, or I'll find the right member of our team to jump on a call with you, and they can look at some software that we have that will allow our team in real time to be able to look at your property, to look at your impact, to tell you what concerns we think we might have with the potential impact to your property. We can walk through the fee structure and the fee agreement, show you what that might look like, show you what any potential costs might look like for expert appraisers or other experts, and whether we think that might apply to your particular impact. And more importantly, we can just generally develop a pre-client relationship that might lead to you working with us one day. The quicker we can do that, the quicker we're able to submit a letter of representation, let the folks that are in power on this particular project know that we're involved, and that'll save you and your family, or you and your company, from having to deal with those initial preliminary communications, negotiations, and ultimately we'll be able to advise you as to your rights throughout the entire process from start to finish. Again, Michael Gault on behalf of the Bell Carrington eminent domain team. This is the first one of these we've actually done live in a while. So again, I apologize for my diaper stash up top. I think you're able to see kind of where I am in life, but happy to jump on with you, happy to speak with you. And we hopefully are going to hear from you and work with some of you in the future. Thanks again.